Thanks, Peter, for doing this. Peter, everybody knows Peter. He's been a trial lawyer in St. Louis for about 57 years. He's got about 150 plus trials. He's tried more cases than most folks that I know. He's a mediator. He's been a leader in his firm for years. He's a leader in the legal community with the Lawyers Association, a variety of other things. He and I have battled each other in cases. He's a pleasure to be on the other side of the V in these cases. Both for me, victories and losses. So I couldn't think of anybody better to come and talk about some of the lessons that he's learned and wisdom to share with us about trial practice. Thank you, Peter.
Gary, thank you for that kind introduction. It's always nice when somebody asks, would you come and speak to a group of lawyers about what you do as a lawyer? And I said, Gary, I'd love to. And the last thing I thought at the time was, but hold on, the Blues are going to be playing in the Stanley Cup Final, and Game 2 is the same night as the CLE. So to say I've been consumed with anxiety where all that's concerned would be understating things quite a lot. It's impossible to enjoy these games. You know, when the puck's in their end, fine, nothing bad can happen. But when the puck's in our end, no, it's just, you know, anyway, I'm consumed with anxiety about the whole thing. Talk about mistakes. I titled this How to Lose Big Money in St. Louis County because I've been proving that can be done for years. I've lost cases in St. Louis County more than I've had hot dinners, it feels like. And as I look around the room and I see people that I've tried cases with, people that I have cases pending right now with, and I say to myself, what could I possibly say to these people? Like, I'm going to tell Clem Burns how to try a case, or Dennis Curlin how to try a case, because they know more about how to win big money in the county than I do about how to lose big money in the county. But it can be done, and I have 31 slides, so I figure if I go just a minute or two between slides, that'll give me the whole hour. But just backing up one, I noticed, call Bob Plunkett. If you have any questions about anything I talk about today, call Bob, because clearly he was the one who did this PowerPoint first before me. I want to talk for a second about what happens before the trial. You know, the simple fact of the matter is that fewer cases are being tried today than ever before. Somebody threw a figure at me that only 5% of all cases that are filed actually go to trial, and I said, that's way off. It's more like 1%, maybe less than 1%. And I think nationally, statistics show that there are fewer cases being tried today than almost any time in the last 50 years. There are more cases tried in 1969 than there were in 2019, or there will be in 2019. So you really sort of ask yourself, where does all the work that goes into preparing a case for trial go in an era where mediations have become so much more popular? You have contractual arbitration that takes away people's right to jury trials, and you have just this tremendous disincentive to go to trial. I know on the defense side, we are given authority to try cases far, far less often than any time in my career, and there's a simple reason for that, which is the fear of something worse. That's the whole reason why cases get settled, because you're afraid of what might happen. And it's the pretrial work that creates that feeling of risk. All the work that goes into getting a case ready for trial, the pleading stage of the case, the discovery stage of the case, the motion stage of the case, the pretrial negotiation, and then the, you know, all the work that a lawyer does developing theory, strategies, and how to handle your evidence and how to handle the people involved in your case. And I saw a colleague here in the room, and we were talking about why the last big case I lost, I said, gee, you know, right up until the moment the verdict came in, the jury was in the box, and I was positive that I was going to win. And when they announced this multi-$100,000 verdict against me, I say to myself, how did that happen? And the other lawyer, who was being very gracious about it, said, well, it wasn't because they hated you. He said, it was your client they didn't like. And I said, okay, well, that's small comfort, I guess, under the circumstances. the trial of the case begins long before the jury sits in the box and the judge tells you it's your turn to make the opening statement. If you look up what the Missouri rules and the federal rules say about pretrial conferences, one of the things that they emphasize is that the first and last points on this cell, which is the goal is to expedite the disposition of the action and facilitate settlement and aid in its disposition. I had a federal judge say to me one time that his job is not to decide cases. His job is to dispose of cases, okay? So they were always looking for ways and means by which that can be done. And the easiest way to do that is to encourage the parties to settle it. And that's just what the court's motivation is, because for every one you get rid of, there's 2, 3 coming up in the pile behind it, okay? It's like this never-ending myth of Sisyphus where you're pushing the boulder up to the top of the hill, and then you get it almost to the top and it goes to the bottom. That's the life of a trial division judge these days. So spending days, weeks, dare I say it, in trial only delays the disposition of all of those cases coming behind you. So never mistake the judge's encouragement to discuss settlement, consider mediation. What can we do to make this easier to get resolved, for anything other than the basic motivation that the cases have to be moved because there's more coming behind than there are right up to you. Now, trial settings are wonderful things, but when it comes time to have to get a case continued, you have to look at Missouri Rule 65. I might be wrong about this, but I don't think I am. I don't believe I've ever objected to a case getting continued. I am so happy. It's like your birthday and New Year's Eve and everything else. Oh my God, thank God this case doesn't have to be tried. So you get the case continued, and I realize all you're doing is postponing the agony. I get that, but in the short term, it's like that scene where the guy hits himself in the head with the shoe. Why is he doing that? Because it feels so good when it stops, he says. That's what it's like when a case gets continued. And I point this out only because the rule is very strict. If you have an opponent who, unlike myself, is not happy to see that a case gets continued, and you don't have consent to the adverse party, a motion to continue a trial case requires an affidavit. And it has to be either the applicant or if the attorney doesn't fit this description, a credible person, as the rule describes it, as to the reasons why the case is going to be continued. And the most common or frequently cited reason is the absent witness. And so if you're going to ask that a case be continued, don't forget the strictures of Rule 65 that says that you have to support the application with an affidavit, and you use the magic words there that it's not due to the connivance, consent, or procurement of the applicant or vexatious or delay, but good faith for the purpose of obtaining a fair and impartial trial, which is what everybody says they want, whether they really want that or not. I wanted to take a second and talk about voir dire, because I think the trial lawyers in the room will confirm that more cases are won or lost because of what happens during voir dire than for any other reason, okay? Who your jury is, how you pick that jury, who you successfully get off the jury, and who you're stuck with of the ones that you can't get off the jury these are the people that are going to decide your case. It's important to devote the kind of time, attention, and preparation to jury selection that the process deserves. Obviously, voir dire means to speak the truth. It talks about preliminary examination of a person's qualification to sit as a juror, how many you get. In the day, the court would bring in only enough jurors to make sure that each side strikes, which is 3 per side. No matter how many parties there are, there's only 3 per side. And you get 18, strike 3 each, you end up with 12 of a fair cross-section of the citizens in the county for which the jury may be impaneled. Today, voir dire is a lot different than it was when I first began trying to pick juries. And there's a number of different reasons for that. One of them is one thing that was talked about earlier, the fact that today's jurors are so much more aware of the legal world, legal services being offered, marketing lawyers, advertising lawyers. There's just a lot more of that than there ever was. But what you hear lawyers who practice personal injury law for a living, and Gary knows this better than anyone, the necessity to discover those jurors who are not just maybe contrary to the position that a person who's been injured might sue for money damages, but the people who are downright hostile to that proposition. And you have more of that today, or the perception at least is that there's more of that today than ever before. And so identifying persons who can be struck for cause is the big goal I see being attempted to be achieved by attorneys trying personal injury cases against me. Obviously, there are statutory concerns about jury service. You must be 21 years of age, a citizen of the United States and of the county issuing the summons. You can't have been convicted of a felony unless your civil rights have been restored. Able to read, speak, and understand the English language unless adequately accommodated. You cannot be on active military service or a judge of a court of record, or otherwise incapable of performing the duties due to mental or physical illness or infirmity or in the judgment of the trial court. One of the things, and honestly, we talk to people all the time about, do you really want your case decided by 12 people who aren't clever enough to get off jury duty? We see that all the time. Persons are entitled to be excused from jury service because they have served within the last 2 years. Seeing Judge Ryan here, you get so many people in the city of St. Louis particularly that are called over and over and over again. You really do get an experienced panel on the one hand, but enough's enough. And if you've served within the last 2 years, you're capable of being excused due to hardship. The statute, or the rule, also includes exemptions for nursing mothers, which sounds sexist to me, but okay. Absence from regular place of employment would adversely affect the public safety, health, welfare, or interest. Financial hardship or physical hardship if the juror is absent from their usual place of employment, but that doesn't mean that they are going to suffer some financial hardship. It has to be undue or extreme financial hardship. Licensed healthcare providers can be excused, employees of religious institutions whose constraints prohibit jury service. One of the things I wanted to address just for a second is who these jurors are that we're getting today. And again, segueing slightly into what we heard about in the last hour, the prevalence of social media is so predominant today. Over half of all the people summoned for jury service fall into either the millennial category or the Gen X category. And so that means, and I was shocked, frankly, to look this up the other day, that's anybody under age 45. Okay, and so technically if you're 45 to 65 today, you're still in the baby boomer generation, or is what they call the silent generation, meaning they don't have this fancy nickname applied to them. But the other thing that's kind of surprising when you realize, at least I was surprised when I realized it, is how tuned into social media the millennial generation and the Gen X generation are. More than half of people who fit into that category get their news from Facebook. Get their news from Facebook. I was astonished to see that. Almost all of them are on Instagram, Snapchat, or other forms of social media communication. And I mention that only because a lawyer who's going to pick a jury has to understand one of the points that Tyson made or Jim made earlier about how short people's attention span tends to be who rely on that as their source of information.
How have you changed your voir dire in light of that?
I find myself in the old dog, very difficult to learn a new trick in that category. And I think the points that I'm going to make a little bit later about how to make an effective opening statement fall also in the category of how to do an effective voir dire. And the biggest lesson where that's concerned, as far as I'm concerned, is to be direct. Okay? The last thing that you want to do is have an opportunity to have somebody's full attention and fail to take advantage of that opportunity.
Peter, do you research the prospective veneer about what they look like on social media, or do you have your staff do it before you pick, if you get the list on a Friday, or try to turn it around that day?
Yeah, again, the challenge with that, of course, is that in your ordinary everyday trial that is going to take place either in St. Louis City or County, you have no idea who your jurors are going to be until they're literally called into the courtroom. So you get your list, and if you have the staff and you have the technical capability, one of the things that the new rule about peremptory challenges is that you have to do all these things within a reasonable time. That means while the jury's sitting there, okay? So if you're going to research somebody's Facebook profile or Instagram profile or CaseNet history, you need to do it immediately. Now, consider what we're talking about there. There might be as many as 25 or even 35 potential jurors, and you're going to do this research about every single one of them to find out if their answers to the question, have you ever had a personal injury lawsuit, was an accurate one or a fair one, or have you ever been involved in litigation for other reasons? So you have a paralegal or two paralegals looking up everybody's CaseNet history and Facebook, one on Facebook, one on CaseNet, to look all that up. Consider the way all this used to be before the rule changed and called for that, or before the internet existed, or before Facebook existed. It was impossible to do that. You did it the old-fashioned way, by looking at somebody and accepting their answers that they give to questions as being accurate and honest. Instead, you have this secondary method to try to figure out if somebody is being forthcoming about their litigation history, about their feelings, and it goes down to this basic question about challenges for cause in 494470. No person can be a juror in the same case in which they've been summoned as a witness, but no one who has formed or expressed an opinion concerning the matter or any material fact in controversy in any case that may influence the judgment of such person is eligible to serve as a juror. Well, that's a rather involved undertaking, because you might get somebody expressing an opinion during voir dire. Okay, says, well, I think personal injury attorneys are blood-sucking whatevers, and I think claimants in personal injury cases are all fakes or frauds. Well, if somebody is that direct about it, yeah, they're going to fall into the category of a person who's expressed an opinion that affects and influences their judgment. But what if somebody's only thinking it, okay, and doesn't say it, okay? That's how these secondary level of questions about, and this is something, frankly, you see very, very seldom, that people ask somebody's political affiliation. People ask, do you follow President Trump on Twitter? And do you press like every time he, says something? People ask, what political party, do you belong to? And so if you're going to find out about somebody's history in a manner that is sufficient to fall into that category, somebody who has or has expressed an opinion about a material fact in controversy. For example, a person's right to money damages, a person's right to future damages, a person's right to collect damages for pain and suffering. There are people who will say they don't believe in those things, but far more often you're going to find people who believe that but don't say it. Okay, and so a well-done voir dire is going to elicit facts that reveal those feelings. Sorry.
No, this is great, and you said, about the challenge for cause. Let's say I get some people who, they don't go as far that way, but they say, you know what, I need a little bit more. They always say, I need some more to get pain and suffering damages. Or they say, you know, I don't know if I'll do 51%. I may want more. And let's say I get them to go 70 or 80%. Or let's say I get those indications and I get them saying basically that they have opinions that may influence the judgment. My question is, when you get up, how do you rehabilitate them and bring them back so that I can't strike them for cause? Because my argument is, I say you can't use leading questions, and there's some other stuff in that, but what are your tricks to try to bring them back to make me use them as preemptory?
Well, there's two ways to do that. First of all, if somebody who says something like that and is very categoric and definite about it, that person may be lost to you already. Okay, and so it doesn't matter if I get that person to say, oh, sure, I can follow the court's instructions. I can base any verdict I return on the evidence. I'm not going to, do those bad things that Mr. Berger thinks I'm going to do. But you can use that person to help rehabilitate other jurors also. So any effort that's made to try to rehabilitate a juror, to pull them back from the brink and maybe get them say, no, you misunderstood me. I can follow the court's instructions, but you asked me, what do I think about that? This is what I think about it. If you haven't saved that person, you may still save others who see what's going on and want to serve. And I'll say, you almost are as nervous and worried about the people who want to serve as about the people who are desperate not to serve, okay? Because somebody who wants to serve, frankly, you almost think that there's something wrong with that person. Why, you have no idea what this is like. This is not a pleasant experience, sir. But rehabilitation is a key part of jury selection, and obviously the key part of it is to get a person to commit, no, I can base my verdict on the evidence in the case and I can follow the court's instructions, whatever those are going to be. You get somebody to say that, it's the best you can do to get somebody back who otherwise might be subject to, and rightly so, to a challenge for cause. I want to talk about Batson. Batson comes up, wrong way. Batson comes up all the time, and which is, particularly on the defense side, if you use your peremptory challenge to strike someone who is a person of color or their gender or their ethnicity, a potential juror based on face, I didn't like that person's face, you say. No, that should be race, although, maybe you didn't like their face. Maybe that was the reason you're getting rid of them. And so if somebody says Batson, there's a burden shifting. If it appears on the face of the matter, so to speak, that a person, let's say, who's black has been excluded from the jury, it's not Batson exactly, it's Edmondson is the case that applies Batson to civil cases, and there's a burden shifting to require that if a prima facie case of race discrimination is stated, the burden shifts to the striking party to offer a race-neutral explanation for the challenge. And so if it's your intention to strike someone who falls into one of those protected classes, the person who does that has to be prepared to offer a race-neutral explanation as to why that person is going to be stricken. Maybe you didn't like their face instead of their race, for example. No, they said something that justifies striking them, again, peremptorily, which in theory you can do for any reason other than race, ethnicity, or gender. We're talking earlier about juror non-disclosure. The rule's very specific and it's new from a couple years ago. The court shall give parties a reasonable opportunity to conduct a reasonable investigation as to whether a juror has been a party. That means they can look at CaseNet, must be completed before the jury is sworn. So you need somebody, if your intention is to do that, you need somebody to do it. Why? Because if you don't do it, you can't come in later and say that person lied about their litigation history. It turns out they did have a bunch of Nadim represented 10 times in personal injury litigation, and they didn't say anything about it when I asked about it. Two problems with that. One, You need to make your questions very clear and precise when you're asking about claims history or litigation history. 2, the non-disclosure has to be purposeful and not inadvertent. And 3, you better have taken advantage of the opportunity the court is going to allow to conduct this reasonable investigation, because the one thing that frankly this says to me is that the courts of appeal are very, very reluctant to overturn jury verdicts. There's simply a sanctity about that process, rare as it is nowadays, that courts of appeal are very reluctant to overturn verdicts for a reason like this that could easily have been accommodated if only the court and the attorneys involved had done their job correctly. And this rule came into existence, frankly, to address that very problem. And if you don't do that job correctly, you're not going to get relief on appeal. Talking about juries, I looked up some statistics. There are just under 1 million people who live in St. Louis County. There are just over 300,000 people who live in St. Louis City. There's almost 400,000 people who live in St. Charles County, and just shy of 250,000 people in Jefferson County. So these are the sizes of the jury pools that we're looking at. Almost half of all the jurors who are called are in the age range of 21 to 45. 65% use Facebook for their news. Half check either something called WhatsApp. Who's on WhatsApp? Let's have a show of hands. You're on WhatsApp. I had never even heard of WhatsApp before I looked this up. Also, since the 2016 election, believe it or not, Twitter use has increased every year. Okay, so people are looking at that shit more often now than ever before, if you can believe it. And honestly, people believe it. People read it, and it is now a substitute for actual information. It's a substitute for actual news. Walter Cronkite, where are you today? Because people are getting information and getting so-called news, whether it's real news or fake news, from some pretty unbelievable sources. Okay, so before we leave this whole issue of jury selection, I mentioned those figures because you have to know who these people are that are coming into court and how they're getting their information, and how do you influence, how do you persuade, how do you advocate in front of these people? Well, you have to develop memorable themes. You know, when you think about your case, what is the thing you want jurors to remember? What do you want them to know? You have to go to that immediately and don't waste time with things. When seeing Mr. Anderson here, when we instruct on trial practice, I tell people, look, when you're going to do an opening statement or begin your voir dire, don't start by saying, well, this is the opening statement, this is my chance to make an opening statement, so I'm making my opening. No, you start with something good, okay? Start with the best thing that you have, all right? And don't fiddle around or whatever. And you have to personalize it, not necessarily about them individually or you individually, but the case individually, and particularly the people involved in the case. Again, this last big case I lost, one of the things my opponent, again, who was very gracious, said, you know, no, they didn't like your guy. They liked my guy, and they didn't like your guy. And I thought, you know, maybe it is just as simple as that. You know, if they like you, they're going to find a reason to find for you. And if they don't like you, well, you're probably on my side of the case. Obviously, don't avoid bad facts. That's like the most important thing. If there's something bad about the case, don't let the jurors hear about it for the first time from the other guy, okay? You need to come out front with it. If there's something bad about it, likewise, storytelling and visualization is very important. I think particularly in the Gen X or millennial, they want a picture, and whether it's an actual picture or a picture with words, they want to be able to visualize things. I think you let the case sell itself. It's a mistake to exaggerate. You don't want to move around too much, which is distracting. You can modulate the volume and tone of your voice to create emphasis, and never omit the idea that you need to tell the jury what you want them to do. Gary is excellent at that. This is why you're here. This is what you need to do. And you educate them that this is what you want. They want to know what you want, and they will not infer that. You need to be direct about it, and that gets to the issue of damages. I think it's a mistake on the plaintiff side not to confront that in the beginning. There was a verdict in St. Louis County late last year where in a case where the plaintiff never submitted any medical bills, the plaintiff never spent a day in the hospital, never had any surgery, and the lawyer announced in voir dire that he was going to be asking for $5 million. And you know, the jurors, they wanted to know that. And honestly, they're certainly not going to give you big money if you don't ask for big money, okay? And they sold the case, and I don't mean to say that in a negative way. They advocated for a large award, and the jury returned a large award that was just shocking to everybody involved, I think, except probably the lawyer who presented that case, okay? Because he was convinced that the case had big value. And he was able to convince the jurors that the case had big value. They didn't give him $5 million, but they gave him $2.5 million. And the thing that got me about it is that, you know, jurors don't think the same way that I do. They were not hidebound to the idea that there has to be some relationship between the award and numbers, numbers like the special damages in the case, the chalkboard lost wages or expenses of medical care or anything like that. It was more like, this was the human element, this is the harm that was done to this person, this is how this terrible injury affected this person and how it's going to continue to affect this person every day for the rest of their life. And they were convinced of that and awarded millions of dollars in a case that no one except, I think, the lawyer who presented that case was prepared to accept or believe that in St. Louis County such a thing can happen. But it does, and I think the lesson, among the lessons there is, there's never been any such thing as a bad settlement. That's the one thing I would say on the defense side. But on the plaintiff side, you know, aim high. Don't feel like you're making a mistake by asking for a lot of money. If you don't ask for it, they're never going to give it to you, okay? And if you persuade, if you sell the case the right way, by some of the things I said, not exaggerating it, not overselling it, a jury will go along with you if they also believe that the damages in the case are very great.
Peter, do you see more plaintiffs not putting in medical, putting in those things to anchor low? But isn't there a danger to that as well?
You know,
and it has to be the right case.
It's funny because there's experts here, and Debbie Champion would probably agree with me that she's an expert. No, that she has seen that more often in recent years than ever before. This is the law of unintended consequences, and its wisdom. Our legislature is fiddling around with paid versus billed, and we're going to let it both in, and never at a loss for creativity. The plaintiff's bar says, well, then we're not going to admit the bills at all. And if we don't admit them, you can't admit them because they're an anchor. They tend to like a magnet pulling the case down as opposed to a springboard to other bigger things. Bill.
Peter, I don't sell many cases over the phone with adjusters anymore because of that exact reason. They seem hell-bent to say, well, if they only have $3,000 in bills paid over someone who might have 80,000 billed. And I'll say, well, that's not the law. When I argue the case with the jury, that's not what I'm going to say. How do you deal with your adjusters?
Well, in the old dog, not easily learning new tricks category, you are working against the career-long assumptions, presumptions, and prejudices that people have about how to evaluate personal injury cases. I see it, frankly, far more often in the cases that I mediate than in the ones that I try to settle, because I thought judging, by how many of the ones I'm lucky settling, that I've done a fairly good job of getting the kind of money necessary to get the cases settled that I handle. What I'm seeing far less often is getting the kind of money that I think people ought to pay in cases that I mediate, because you run into this feeling, well, they only have X in medical. And I said, okay, now you're talking about billed versus paid, and so often, and the people who do personal injury plaintiffs work in the room know this, so often the people that you're representing really, really, really need the money. They really need the money. They've already spent this money, okay? They need it so bad. And so they're desperate, and they will take almost anything, and there's a huge challenge sometimes to get people to slow down. We'll get better. It'll get better, and get them to resist the idea that I have to have this today. So that's very, very difficult. But you can lead a horse to water if people are not going to open their minds and let this idea that you're talking about, that this is not how this case is going to proceed. We're not going to, only argue that I'm entitled to 3 times my chiropractor bill as the value of the case. And that's when it comes down to selling the damage, selling the harm, selling the injury, rather than the amount of money that it cost. I just think the weight of experience that most professionals on the claims side, is that oxymoronic, claims professional? The people on the claims side of things are used to doing things a certain way, and it's only, and you use anecdotal evidence like these huge verdicts and the unpredictability of juries and the potential for bad faith when cases aren't settled within coverage and what their obligations are. We had a mediation the other day. They didn't want to pay what it was going to cost, and the plaintiff was willing to compromise a little, but they had in mind that it had to be an X number, and I didn't think that was so unreasonable, but the challenge was getting the other side to agree to do it. And what I tried to do to talk them into coming around in their point of view was to say, here's the problem you have. It only gets worse for you from here. Because if you don't settle, they're not going to take the policy anymore. They're going to want more than that. And that means you, defense lawyer, are caught in this terrible trick bag where you now have to tell this insured person that their insurance company had an opportunity to settle this case and didn't do it, okay? And so you have to write the hammer letter. You have to get the insurer to agree that you'll agree to indemnify the defendant for any liability he has, regardless whether it's covered or not, okay? This is the ethical obligation that you're embracing by virtue of the fact that they're not paying, okay? And so you say all those things and they still won't. They still won't come up with the money necessary to settle the case, and you just say, look, this is the bed you've made for yourself, and if that's the way you want it, that's the way it's going to be. There's really nothing else that can be said about it. Opening statements, much, much more important than closing arguments. When do you have the jurors' full attention, ever, at the course of a trial, more than you do during opening statements? So the opening statement has to begin with something good, it has to end with something good, it shouldn't be too long, and you really need to address the issues in the case directly, forthrightly, and immediately. Evidence, this is not a CLE on evidence. 490.065 talks about the new Daubert standard that's been adopted by statute in Missouri. Talk about how you get an expert opinion is and what the foundation for that is. Objections, when we teach trial ad, I tell the students, learning how and when and whether to object is one of the most challenging things a trial lawyer ever has. Doing it well, it's well done. Doing it too often, you make yourself a pest. The worst thing is to make an objection and not get sustained, okay? Overruled, you're kind of slink back to wherever you were, but somebody says sustained, it's like, yeah, do you hear that? But common objections, argumentative, Your Honor, that's been asked and answered, assumes facts not in evidence, best evidence rule, that's a compound question. No foundation, golden rule. How would you like it if this happened to you, ladies and gentlemen? Hearsay exceptions. There are more exceptions to hearsay than Carter has pills. It's an admission, it's a business record, declarant otherwise unavailable, a dying declaration, I like that one best. Declaration against financial or penal interest, excited utterance, former testimony, past recollection recorded, public record, state of mind. I'm not offering this for the truth of the matter asserted, Your Honor. It goes to show a state of mind. And you know, at least perhaps there's a chance it'll come in if you say that. More objections, reference to insurance, character evidence, lack of knowledge, lay opinion without foundation, leading question, testifying in a narrative, privilege, redundant speculation, the dreaded spoliation, subsequent remedial, unresponsive. You know, if you've ever been in trial and you're going to try to impeach somebody with a prior inconsistent statement, it has the potential to be the highlight of the entire proceeding. And it's the most important, probably most understood kind of impeachment. A witness testifies to certain facts, and there's proof that the witness has made a previous statement that's inconsistent with his present testimony. What's inconsistent? Well, it's conflicting, and it can be used to impeach the witness if he testifies in court to contrary evidence, to show the inconsistency of the statement. The court has latitude in determining what is and isn't inconsistent. Generally accepted view is that any previous statement that has a material variance between the offered testimony, there's four parts of it: repetition and commitment. Get the witness to commit to the testimony alleged to be inconsistent. Today you testified, today you say, and then you accredit the prior statement. Have you ever said contrary to that? Oh no. But you say, look, the prior statement was the one the jury ought to believe because it was made under circumstances of reliability, in a deposition, before witnesses, in an official proceeding, to a policeman, if it's in a deposition, subject to the penalties of perjury, represented to be truthful at the time, and then, oops, yes, you're right, I did, I lied, you know. But that done well is terrific. Done poorly, it's awful, okay? So if you're gonna do it right, and don't do it for some collateral or stupid, off the point. It's gotta be good, you know? It's like when an adjuster says, oh, we've got surveillance. Oh, really? Okay. Is it a home run? Because if it's a home run, we'll use it. But if it's just a single, it's not worth using it, okay? You have a guy changing a tire who's supposed to be, you know, totally disabled, fine. That's surveillance we can use. If it's just some guy who just carries the groceries inside, no, you can do that. You can do without that one, meaning. Judicial notice is great. I think it's helpful in trial when you go to the court and you say, I want the court to take judicial notice of something. And if they agree, I think that has certain persuasive power. It has to be one of common knowledge, settled beyond doubt, and the knowledge must exist within the jurisdiction of the court. Facts that cannot reasonably be disputed: the sun rises in the east, or a body in motion travels 1.5 feet per second. That's good stuff and can be helpful in any case involving time, speed, and distance, such as auto collision. You have two, you get the other one, and maybe it says something that's helpful for you. Don't forget to make motions for judgment at the close of all the evidence and in the close of the plaintiff's case. Why? You're going to waive issues on appeal unless you do it. The whole point of it is to bring to the trial court's attention matters that the trial court can correct. And if they don't do it, that's when you get the trial court erred. You know, there's no grounds for appeal saying Peter Dunne erred and that he asked the wrong question, or Peter Dunne erred that he shouldn't have taken this case to trial in the first place. That's not grounds for relief on appeal. Closing argument. There's a constitutional right to make one. The party with the burden of proof goes first and last. It can be limited depending on, you know, various things the trial court will consider. You know, I don't object during closing very often. If somebody is making personal attacks against me, my response is I must be doing something right because they're taking up time during closing saying what a sneak I am. as opposed to talking about the problems with the case. So, you know, name calling, et cetera, I tend to ignore that sort of thing. Mentioning collateral sources, telling jurors to send a message. How would you feel, ladies and gentlemen, if this happened to you? Quotient verdict with mathematical formulas. Prejudicial comments, personal, like calling jurors by name. I've had people do that. That's probably not okay. I know this person's telling the truth because, you know, whatever, personally vouching. So if that happens, what do? Well, you call it to the attention of the court. There can be an admonition and censure. You can ask the court to give a curative instruction to disregard those improper statements. They can cut you off right there. On extreme cases, you can have other kind of sanction against the attorney, and obviously one of the things that can happen is a mistrial or ordering a new trial, depending on what happens. Anyway, trial practice is complicated. When Gary said, "Hey, you can talk about anything you want," I said, "Okay, well then that's what I'll do." But I see my time is almost up. Hopefully there are no questions, but if there are, we can talk about them later. Thank you.